Thank you, Bob. Those moments of insanity continue, I'm afraid. I want to thank you very much for the invitation and thank all the organizers. This is truly a wonderful conference, and the speakers, at least right up until this moment, have been absolutely fantastic and among the most knowledgeable people over Colorado River matters. I'm honored to be among them. Unfortunately, I should say, there's been so much ground covered that I'll be able to stand on the shoulders of those who went before and just call attention to some of the things that they said, digressing only occasionally into a few points that I wanted to add to what's happened before today and yesterday. The Colorado River Compact is surely something that is discussed in a heated way, and the fact that you chose the possibility of doing something other than the compact is understandable. That is a topic of discussion in a lot of places. The cartoon that's up here is hazy, so don't try to fix it. It's my attempt to steal it from a high country news issue that some of you may have seen. There's a picture of a showgirl on top of a Las Vegas fountain here, looking down at some cowboys, the 7 of them, representing the 7 Colorado River Basin states, and it says across their shirt, Colorado River Compact, and the showgirl is saying, "Show me what you've got, boys." And so we ask too much of the Colorado River Compact. Patricia Mulroy, who you heard earlier, surely one of the most visionary and one of the toughest-minded people in Colorado River Basin affairs, said this of the compact not too long ago: "If there's no way to accommodate Nevada, then Nevada has no choice but to consider the compact broken." Now, what she said then and some of the things she said today would have been heresy some years ago. Suggesting that we talk about the compact in anything other than religious terms would be looked on askance by anybody who was a leader in Colorado River Basin affairs, but we do talk about it that way these days. In Robert Adler's new book, which I've had the privilege of reading in galley proofs, and I commend to you, please take that order sheet out of your materials and order it. You'll love reading it. Anyone who's here and who's stayed till the end of this conference will love reading Adler's book. What he says of the compact is this: "All of this suggests a need to revisit the water allocation arrangement reached in 1922 in light of significant new information and changed circumstances." And then he goes on to say, "From the perspective of environmental restoration," a real focus of this book, "and even basic compliance with the Endangered Species Act, the compact, is simply not working." But then he says, "We have not yet had the wisdom to recognize that ecological, economic, and political conditions have changed so dramatically since 1922, and the greater scientific understanding of the basin's current and potential future hydrology and climate suggests that the Colorado River Compact and other aspects of the law of the river should be reconsidered." And then he goes on and says, "A better approach to the immense complexity of Colorado River restoration may be to broaden rather than narrow our focus and to consider a wider range of issues and potential solutions that are reflected in existing efforts and institutions." And I'm going to say to you that I don't think the compact should be the focus of our concerns either. There is so much more in the law that we need to look at. The compact, after all, isn't, as I will try to make the case in the minutes I have with you, the bugaboo here. It's not standing in the way of solutions, and we can find solutions within it. One argument is that we're our own worst enemies in trying to solve these problems, and it is not the compact that's in our way. There may be legal issues that arise from the larger context of the law of the river. We can solve those too. Patricia Mulroy captured it all in the first part of her speech when she said, whatever 7 states agree to, we can do. And that's just as Justice Hobbs concluded when he pointed out the compact, after all, can be amended or interpreted as 7 states agree. Well, let's go to certain realities that we're faced with right now. The first one is overallocation. The Colorado River has been overallocated, what we casually call sometimes entitlements, as you've heard earlier in this conference, add up to 16.5 million acre feet, or so we thought. This chart, which is difficult for many of you in the back to see, but is easily interpretable, shows some bars that start back in 1894 in the beginning of the period of record in the Colorado River, and go up to a year and a half ago on the right side of the chart. What you can see is that the darker lines indicating historic flow, and the gray lines on top of it, virgin flow, have generally declined over time. And if you look at the period in the 1920s, about a quarter of the way from the left, if you can't read the numbers at the bottom where you're sitting, and 1922 being when the compact was negotiated, you can see that there's been substantial disappointment of the 16.5 million acre foot commitment, which is indicated by the red line running across there. More realistic has been the blue line, which is indicative of the tree ring surveys and average flows indicated by them. And I know you've heard a presentation on that subject. Reality number 2 is growing demand. You've heard a lot about this too. Arizona's population grew 40% in the 90s. Colorado, our state, grew 30% in the 1990s. Las Vegas, sometimes the fastest growing city in the country, has Clark County surrounding it. Clark County water use doubled in the period 1985 to 2000. We have agricultural uses. Of course, as Pat Mulroy pointed out, the largest use of urban water is lawn watering, carefully applied. And then, I hope Pat's still here, we've got a couple of images of Las Vegas hydropower, which provides great benefits to society. And here is they're illustrated to those of you who enjoy gaming in Vegas. This is thrilling. Then there's golf course watering, two images from Arizona. And then this image of beneficial use. I realize it only takes 3% of Las Vegas's use, but it is striking to see that water playing in the desert. The driver for consumptive use in the Colorado River Basin has been demographic movements. In the lower left-hand corner of this map produced by the Forest Service a few years ago, you see that there's an influx of population from Far East and Latin America into Southern California, and then there's an out-migration into other areas. The darker colors, the reds, are the areas of largest and fastest population growth. A remarkable map for what it tells us about the meaning for water demand. And most of that water demand is not where the water occurs in the Colorado River. It has to be carried across the desert in canals. And typically is used outside the basins. Those of you who can see this map, the red arrows show the movement of water outside the Colorado River Basin, where most of the water, interestingly enough, is used. Third reality is the existence of vast tribal rights. Now, Stan Pollock talked about that, and Justice Hobbs just alluded to the tribal rights throughout the Colorado River Basin. Enormous tribal rights exist, many of them not quantified. This map shows the adjudication of Arizona versus California and the approximately million acre feet of water that was allocated in that case, and reopening of it in the 1980s. Now, we've known about Indian water rights claims in the West for nearly a century. For 45 years, we've known about the existence in the Colorado River Basin, but I will submit that they've been largely ignored and disrespected over time. And as I will remind you again at the end of my presentation when I get to some recommendations, justice and good sense, as well as it being just the right thing to do, should move us to quantify these water rights, to recognize them, and to take them into account, not to mention including tribes at the decision-making tables throughout the Colorado River. Fourth reality that we have to cope with is climate. We've heard quite a bit about that in these sessions, and Dr. Ingebretson talked about the climate change part of it. Again, the image that I showed earlier illustrates that something has changed. There is a substantial argument that we are in and have been in at least a 15-year drought. The average for the last 10 years has been about 13 million acre feet, and for 7 of the last 10 years, the virgin flow has been less than 12 million acre feet, again against a 16.5 million acre foot expectation, if not entitlement. Nearly all the high flows that you see represented on the chart were before 1929. So we are facing conditions that simply do not allow the realization of the promise that some saw in the Colorado River Compact. We also know that drought is a condition. It's not an occurrence. It's not something we should be surprised by in the Colorado River Basin. Indeed, the consequences of drought have been predictable, and I digress here to mention a study that I was involved in. Doug Kenny is here from our Natural Resources Law Center. He's was involved in this study as well many years ago now. It really began about 20 years ago. The severe sustained drought study was one that revealed to us the resilience, the relative resilience of the Colorado River Basin arrangement for distributing water, allocating water. But what we found was that Lake Powell and other major upper basin reservoirs would be emptied in a severe sustained drought, and Lake Mead nearly so after a 2-decade drought. Water deliveries for consumptive use in the upper basin would fall to about half of normal levels, and the lower basin, surprise, would be largely unaffected as to its consumptive uses, with the exception of impacts on the Central Arizona project. In all, the basin shortages would be less than 25% of normal demands. Now that's pretty good resilience. What are the really negative consequences? They are on in-stream, non-consumptive water uses, including hydropower, water-based recreation, environmental protection, and salinity control. Power generations would impose huge costs on the losses, would impose huge impacts on the basin. And reductions in water deliveries for municipal, industrial, and agricultural users would be substantial as a result of salinity problems. Recreational benefits would certainly fall. The lower basin states would experience minimal losses to consumptive uses, as I indicated, but the upper basin would be hit with not only impacts on its consumptive uses, but serious environmental impacts. Now, we know, we hear repeatedly that we've got global climate change heading our way. The National Academy of Sciences report that Dr. Ingebretson talked about stated reconstructions of historic droughts, which I was just talking about, along with temperature trends and projections, suggest that future droughts will recur and that they may exceed the droughts of historical experience, such as the droughts of the late 1990s and 2000s, and then they go on to conclude that all of this will be exacerbated by global climate change. Now, I have a couple of charts here that illustrate the impacts of the declining availability of water and the conclusions that we reached in the severe sustained drought study. Now, this pie chart shows the allocation of water under the historical condition of 16.5 million acre feet being available. These are the expectations on which the compact was built. But then if you go to the tree ring estimates, 13.5 million acre feet, you see a radical difference in the upper basin's allocation. That's the blue-gray area on the left of the screen. 16.5 million acre feet, 13.5 million acre feet. The upper basin takes the hit. Now look under severe drought, less than 9 million acre feet of virgin flow. The upper basin gets nothing. The California share remains robust, however, and the 9 million acre feet is divided as indicated here. All of this suggests some equity issues to be resolved. Reality number 5, environmental and recreation demands, they're real. Robert Adler's book elaborates on this, and you'll love reading about it, troubling though it may be. We gained our environmental consciousness in the Colorado River not until 1982. By the late 1960s, the damage was largely done. The dams had closed up and down the Colorado River, and we were beginning to feel the impacts on native fish, impacts on riparian habitat. Non-native plants were starting to come in and replace native plants. And all of this, one asks, should have been predictable, shouldn't it have? Well, there was no environmental impact statement done because there was no environmental impact statement requirement. NEPA was passed in 1969. How would those projects have been different? We don't know, but we started to study what we could do about this and what the nature of the problems really were in 1982 as a substitute for environmental impact statements that environmentalists were then seeking. Since then, we have new operating criteria on dams in the Colorado River, most particularly Glen Canyon, and that has resulted in more benign, environmentally speaking, more benign operations. We also have the Adaptive Management Work Group, which creates a feedback loop and so that we can make mid-course changes in dam operations. Unfortunately, the Adaptive Management Work Group has created its own mire of bureaucracy and hasn't moved as fast as it might have. The Colorado River Delta in Mexico, you've heard discussed by others, and that is surely an issue that we didn't contemplate years ago. Endangered fish, represented on this map by the critical habitat shown in red up and down the river and its tributaries, have been the primary focus of attention to environmental issues other than salinity, which I'm not going to go into today in the interest of time. The Endangered Species Act has moved us to address the problem of endangered fish through 4 special programs. I'll have to mention those programs are not connected one with another. They're isolated. To the credit of people up and down the river, they have been largely formed through collaborative efforts, but not without conflict and, unfortunately, without coordination. A couple of images of the Colorado River Delta, which I won't go into any further. And then, of course, recreational interests are of a very high value, both a personal value expressed by people about the Colorado River in terms of amenity values and certainly economic values as well. Now, possible conclusions one can draw from this is, first of all, we need to revise the law of the river. We've got these problems. They've only been partly addressed. Let's get a new compact. And I've already suggested to you my conclusion on that it's not all about the compact. Well, we could solve the problem with vast federal legislation, which would be superimposed upon the entire situation. Alternatively, we could use the law creatively, and that's what I'm going to suggest to you needs to be done. Creativity in the past has largely been misdirected. We've spent a lot of time, for instance, talking about surplus criteria, not shortages. Pat Mulroy mentioned that and waved her hands in disbelief as someone who had to participate in that. Years and millions of dollars spent arguing about what is surplus. And even now, we have intentionally created surplus as a way of managing the river, of a fictional approach to a real problem. Almost all of the efforts of states has been directed at protecting entitlement. When states get together, they talk about protecting their respective entitlements, and it's understood at the door that that's why people are there. They don't talk about values, economic values or human values, ecosystem values, except to the extent it's necessary to respond to legal requirements or the force of the federal government looking over the shoulder of a negotiation. We focused on political boundaries and political rivalries instead of how we can get together. Political boundaries are so terribly important. It's about states, it's about U.S. versus Mexico, and when we put together a multi-species conservation plan, for instance, on the lower Colorado River, that plan, progressive in many respects, looking at more than 100 species, stops its consideration at a straight line along the U.S.-Mexico border. So how do we use the law of the river creatively? First, we need to recognize reality. And those realities I've already indicated over allocation indicates that you just can't consider entitlements. They cannot be filled. There's growing demand. The basin demands are human created. They can be human controlled. The demand is going to grow. We can control the rate of growth. We can't control, as Pat Mulroy points out, how many people will live in the basin. We can control how much water they demand. Tribal rights, they're huge, they're unquantified, they're unsatisfied, they're ignored, it's unconscionable. Climate. The drought, as I've said, is inevitable, and climate change will exacerbate the problem. We have not built that into planning. Most states don't build it into the planning. California has broken out of the gate in doing that, but most of our states simply do not plan for climate change. They will plan for drought. Environmental and recreational demands, these are based on values. They're not technical requirements. They're not amenities. We've responded to the soft expression of amenities to some extent. We've responded to technical requirements in the law. We're going to artificially prop up the habitat of an endangered fish, but we don't look at it as an ecosystem or something that is driven by sound and broad-based values. Finally, creative responses will include seeking flexibility, not limits in the law of the river. We have repeatedly looked for what the limits in the law of the river are. We can't market Colorado River water. That's prohibited by the law of the river. Well, now we do it up and down the river. Steve Clyde talked about marketing water. This you didn't used to be able to talk about this, and Pat Mulroy talked about some of the other limits that were imagined in to the law of the river until it became too important to pull down those limits. Basin-wide planning, gasp. Basin-wide planning, that means states planning across borders for the Colorado River. That's a pretty wild solution, isn't it? The problems that we've talked about on the Colorado River are basin-wide. Natural limits are what we're talking about here, and that's the natural limits created by drought, created by climate change, are basin-wide. They're not something that are state-by-state problems. Over-allocation is a problem that all basin states share and need to share in the solutions for. Ecosystems are obviously something that are not defined by state lines, the two sub-basins of the Colorado River or the international boundary. So solutions can't be those that begin or end at state lines, sub-basin lines, or the international boundary. Oh, and on basin-wide planning, I should point out that the Colorado River Basin Project Act provides for regional water planning. It mandates a regional water plan. It's never been done. We need to use markets more widely. Intrastate markets for sure. Interstate markets, yes. Those things that were anathema only a few years ago, well, now we have them. You heard about the Arizona Water Bank. That is interstate water marketing. Tribal water marketing, off the reservation. These are all solutions that absolutely must be considered. And I know you've heard allusions to the QSA, the Quantification Settlement Agreement in California, and California's 4-4 plan. These are water marketing experiments, even though a free market economist would stand up here and say that can't really be a market if you need to prime the pump with $250 million. But it is water marketing. We need to break out of the limits that we've artificially imposed on water marketing, including interstate and tribal off-reservation marketing, and be more flexible. We need to involve tribes in all decision-making. I've already mentioned the importance of doing that. It's good sense. They have a lot of water, and they deserve to be included at the table. They're sovereigns. Finally, a radical new approach to decision-making. This may or may not sound radical to you, but I submit to you that these suggestions are radical. First of all, cooperation. Pat Mulroy ended her talk making this exclamation point that's at the end of cooperation. It is not cooperation when it takes 8 to 10 years to come up with surplus criteria or the quantification settlement agreement, even within one state where most of those almost all that agreement had to be made. It's not cooperation when you have Bruce Babbitt or Bennett Rayleigh having to beat you over the head to make any progress. This will be a new discovery if we can cooperate around shared values. The concept that we're going to share a river, we have some shared values in it, and stop holding up some phony excuse in the compact or some other aspect of the law of the river as a reason for not doing it. Intrastate operational changes. Now what this means, and this is radical, that each state needs to look at ways in which it can relieve the pressure on the law of the river. Through conservation, through cooperation within the state, and through measures that will make it easier to meet that state's obligations. Now, I speak as a Coloradan here, and it is still somewhat of a radical suggestion in some quarters. I think Justice Hobbs may agree that to say that our primary goal is no longer to develop our full compact apportionment. That mantra has been spoken for decades and decades. That is our goal, to develop our full compact apportionment. Well, it doesn't exist. The first time I suggested that it would not exist is when I was a state official, and I was almost burned at the stake for suggesting that we don't have that compact apportionment to develop, and it would be a big mistake to do that. Look at the fluctuations of drought. Look at that pie chart that I showed you a while ago, showing that in some years it's possible that the upper basin would have no water to use. All the water would have to be left in the stream to get to the lower basin. That is an unthinkable situation. Meanwhile, we're going to develop our full compact apportionment when we're that vulnerable? No, we need intrastate operational changes to make it work without developing any more water. A new basin institution. Now this is pretty radical. It's something that I've suggested in articles. Doug Kenny wrote a dissertation on this. We've had between us several different conceptions of how this would be. A basin forum, a commission, something to bring together people in the basin to make decisions collaboratively about the basin, not just states. Tribes, environmental interests, scientists, everybody who has an interest in the Colorado River somehow would be represented. Not 4,000 people, but you could imagine a decision-making body of 10 or 15 people representing the various interests and making decisions about the Colorado River to pursue the shared values that they have to cooperate to accomplish and to protect. More use of federal power. I'm not talking about electrical power here. The federal government has vast power over the Colorado River, particularly the lower basin. And yes, the past Secretary of Interior, two Secretaries of Interior ago, and the Assistant Secretary of Interior in this administration has been very active in asserting federal power. Not active enough. By pressing the basin states and recognizing that the basin states have no claim on decision making, only a claim to be consulted through their governors when operating criteria are presented, except by custom, the federal government can force states to get together and to have others join them at the table in cooperation. They can motivate these interstate changes and perhaps put the juice into a new basin institution. That can be done through legislation, but it also can be done through the regulatory power that already exists in the Secretary. I want to conclude by saying that we can do all these things that I've mentioned without a new compact, without revising this one. The problem is not the law of the river's legacy, but how we use it. We have to stop refusing to be creative and to see flexibility in the law of the river. Drought and climate change are surely going to heighten calls to do something different. The something different need not be a change in the compact. It means rolling up our sleeves, getting together, stop being religious about the law of the river and start being practical and collaborative about it. Thank you.
We do have time for some questions. Yes, sir.
I would call it out of question. Does the threat of a compact call put a burden on the state of Colorado to tinker with the way we administer water rights under the priority system, given the fact that Denver Water, for example, is a junior diverter serving 1 million people, the water right is junior to the compact?
As you notice, there are parts that I disagree with what David said. Okay, I think the apportionment to Colorado is a legacy of Colorado and is guaranteed, and the apportionment I described had to do with a apportionment that is not fixed, that depends on the available water supply in the upper basin, as long as the lower basin wants that guarantee, which is in the compact. They want to take a call off the river, and there's some agreement that the upper basin won't be called out for its uses. Now that would be something worth talking about. But within Colorado, we have to administer our water rights according to the doctrine of prior appropriation, and we depend upon storage. You know, what I think David missed here is he's talking just about drought. He's forgetting about the good water years where we got to sock it into storage. And I admire the Central Arizona people and the state of Arizona for groundwater banking. I actually think we need to do that if we can figure out how to do it in Colorado. The one thing that you can't do is to ignore the fact, and we learned this from the Hinderleiter case of the U.S. Supreme Court in 1935, when you enter into a compact, the senior rights are curtailed back to what it takes to make the delivery guarantees. We learned that, as you well know, in the Arkansas compact litigation, where we allowed pumping of tributary wells to take place after 1948, and the U.S. Special Master and the U.S. Supreme Court ordered that that be ceased and that be remediated. So we are, as you well know, integrating our surface water and our groundwater as a hydrologically connected basis on the doctrine of prior appropriation. I don't think judges have the right, nor does the government, absent condemnation and the payment of just compensation, to fail to administer the water rights in priority, which would include the storage rights. And storage rights take the available surplus in good years so they can be used in bad years. You know, and that's what the Anasazi did when they were operating those reservoirs in Mesa Verde between 750 and 1180 AD, the 4 reservoirs that were found there. So storage is, as John Wesley Powell pointed out, is indispensable to the management flexibility, which I think David would concede that we need. And lots of these restoration things are going to be done by maybe reoperating our storage. Well, building enlargements, doing underground storage, but I don't think, if the message here is the states are going to have to cut back their water rights and not achieve their apportioned share, I would say that's a dream world. You know, we've got 2.5 million more people to come to Colorado by the year 2030. We are seeing 1 million acres of farmland already taken out of production by transferring water rights permanently. Now the legislature has allowed leasing, dry year leasing, fallowing, rotational crop management, and we're going to start to lose more and more of this irrigated open space. You know, so when I say that the municipalities are going to get a certain amount of water, you know, it's because the Colorado Constitution allows municipalities to condemn the water rights if they need it to serve the populace. Now, maybe not for landscaping, all right? I'm talking about the traditional domestic uses. And whether Colorado develops that 400,000 acre feet more or 500,000 acre feet more that may be available, that's going to be high risk, high capital investment, because we're dealing in an upper basin situation where we can't overdraw. But as far as I know, until somebody makes the proof that we don't need that big storage battery of this that we have in the upper basin of 31 million acre feet to back up the delivery obligation that in the Crystal Creek case, our Colorado Supreme Court said that was the function of the Aspinall unit primarily, you know, we may be talking solutions if we figure out how to guarantee the states their apportionments, because I don't see any state giving it up, right? We can't breach the Commerce Clause by simply allowing private individuals to market interstate. So those agreements are going to have to be made by forbearance agreements or other arrangements within the compact or by amendment, in my opinion. We cannot turn over our conservation of our water resources, our public resources dedicated to our state, to just private interstate marketing. David?
Yeah, I would like to make just 2 points. First of all, the state engineer in our state and others should follow the prior appropriation doctrine in trying to meet a compact call, but need not. Under the Hinterleiter case, there was a challenge to the delivery of water under a compact. There was a challenge to the way the state engineer was closing off water uses as being not consistent with the priorities in the basin, and it was held that the state engineer had some latitude in such times in order to comply with the compact requirement. The other point, well, I agree that legally Colorado has the right to develop its full compact apportionment. I don't think it's practical to have that discussion about how to do it, and it's not a good investment to invest in doing it. It would make so much more sense to say that compact apportionment is theoretically there. We'll enter into water marketing situations where we can get a monetary benefit from the lower basin for not developing that water and ensuring the ability of the lower basin to get it without a fight in drought years and to get it regularly in wetter years. Can we store enough water to get over the drought, the severe sustained drought? Our modeling exercises in the severe sustained drought studies showed that you can't, that there's just not that storage there. We're losing 3 vertical feet of water in every storage reservoir in the basin every year as a result of evaporation, and we've reached the point in storage of diminishing returns for that reason. We'd be a lot better off figuring out how we can get by without developing it and using market mechanisms to gain what benefit we can. But I certainly agree with the very last remark that Justice Hobbs made, that this shouldn't be a matter of wildcatters coming in, as we would call them in the oil business. This is a matter for state involvement in these markets. This is a state resource.
Yes, sir.
Well, things sort of went south for the Anasazi after about 1200, despite those water storage areas, perhaps related to water storage.
The survival of any civilization depends on a dependable water supply. Yeah, and we're not going to stop the growth. And I agree that we're going to have probably less and less landscaping and use of water in that segment. I think we ought to not be real fast about taking all our ranches, the Hay Mountain ranches, out of irrigated agriculture. They're a great open space amenity. They're being bought up by organizations like Nature Conservancy and others, and Great Outdoor Colorado Trust money in our state to keep the water on the land. I call it farming for birds, for wildlife refuges, keeping the irrigation rights in the rural area. These things are not simple solutions. The one thing I am convinced about on reading the literature is that we're not going to put a cap on western state growth. So we're going to have to use more conservation and the first tier of water planning, which would be all we can do on demand management, conservation, but there's inelasticity after a while, as I think was pointed out. So the Anasazi went away, right? We need to stay. Okay, so we have a duty.
So we need to look at things a little differently, a little more.
I think we have the framework in which to do that. I don't disagree with David. But I don't think the state of Colorado has ever said that it's going to forego its apportionment. And under the compact, you know, if and when they make that decision, it's going to be for good and valid reasons. They're going to stand up to the citizens of Colorado, and the other states may have to give on their apportionments too. I want to make it very clear that it's the delivery requirement at Lee Ferry that has already curtailed the upper basin and made it fit within a sliding or flexible curtailment system. They don't have that in the lower basin that I know about.
Given what you just said, given what David said in response to the last question, and looking at David's pie charts, it seems not politically sustainable for the upper basin to take such a small cut of the river under sustained drought conditions. So when you talk about the states foregoing entitlements, are you talking about the lower basin agreeing to forego the delivery obligation? And then do you see that as politically feasible?
I think there is potential political feasibility in getting the lower basin to agree to operational requirements that will allow the optimization of storage, for instance. One example is the equalization requirement between Meade and Powell. It's one of those things that has taken on Talmudic significance, but it need not be perpetuated if what we found in the severe sustained drought study was that if you moved the storage upstream and did sort of a reverse equalization, stored in Powell instead of in Meade, you could protect the upper basins during several of those first years of cutoff when we otherwise would be without water. So minor changes, seemingly minor changes like that, would protect the upper basin. Now, what is the lower basin giving up? It's giving up water perhaps in wetter years that it's guaranteed. There'd have to be some maybe marketing arrangement there that would allow the upper basin to store as the hydrographs started to drop off, so that there was a sharing of impacts. And the economists would say it's best to do that on an economic calculation.
I think that works in the short term, but in a longer term drought, don't you think the 10-year rolling average has to give? And given California's political power and so forth, how is that going to work?
Well, 2 points. The impact on the upper basin was very late in the 38-year drought that we modeled. It was severe, and you could protract the drastic nature of those impacts by the operational change that I mentioned, and you can protract it also by water marketing. We might have had better success in modeling a within the law of the river solution to drought if what we did was a gaming exercise. It was very interesting. There were 3 separate game exercises. Everybody who played the game was tied so much to the rules that they were reluctant until late in the process to get into marketing. They were reluctant to negotiate changes in the rules that flow from, if you will, the Colorado law of the Colorado River. If we were more progressive and said, well, let's just pull back from that, let's do a model that would work in a 38-year drought, you could do better. But we didn't take the study that far. Now, the other question was about political feasibility.
California's willingness to give up on the...
Well, I guess I'll answer a slightly different question that came to mind when you asked that, and that is, can we do any better? Could you do better with equitable apportionment? I don't think so. California would win. Could you do better in Congress? Not at all. California would win. They've got, 10% of the total membership of Congress.
Question for both of you. You both emphasized that the changes that need to take place can occur under the law. But it seems like that in order to really seriously vindicate tribal rights, we do need to make some structural changes, either including the tribes into the compact or federal legislation. So, David, what would it take to really seriously integrate tribal rights into the framework?
two answers briefly. One of them is that tribal rights have to be vindicated, and that is a combination of judicial and negotiated process. But I think you're focusing more on my comments about integrating the tribes in decision-making. And that can happen through some combination of creating a new institution, which is my preferred solution, giving them a seat at the table. Obviously, you can't seat all 20-some-odd tribes that are in the basin, but they'd have to be represented through representatives who were chosen in some reasonable way. They are represented in something like that in the Adaptive Management Work Group. So how do you get that entity created? Either through legislation or through the Secretary of Interior saying, I've got all this power, I'll follow the recommendations of an entity that I will endow with various powers that I'm now exercising. You've got to seat the tribes at that table.
As a follow-up to that, if you do open up interstate transfers of water, should tribes not be given the right of first refusal to lease their water before anybody else?
Well, I haven't thought about the right of first refusal, but I've certainly advocated that the tribes should be participants in interstate water marketing. And in fact, the regulations in the early 90s that were floated by the Bureau of Reclamation had tribes as interstate water marketers, as well as creating a 7-state capability for water marketing. I mean, this was the high point of innovative thinking in water marketing in the Colorado River Basin. It went nowhere, but someday it may be dusted off.
I got to put a caution on this. I think I conceded that the United States Congress can override treaties. They can override Native American treaties. Unfortunately, the tribes have found that out. They can probably override compacts. Is it a good idea? No. Do the tribes need to be represented? Yes. I think we know, however, that their apportionment comes out of the state's apportionment. That's settled by Arizona v. California. I know it's a laborious process. I think the Navajo Nation is an example of a tribe that's asserting its rights in 3 states. Is that complicated? Yes. Are the states going to have to buy off on it when the tribe goes to Congress to get the infrastructure it needs to have wet water? Yes. Does all of that make for negotiation and settlement? Yes. Does the Gila River agreement show that there can be some marketing built in? Yes. See, these things can be put on the table, discussed, and effectuated. But on the other hand, I don't think that the compact should be amended to have all the tribes in the 7-basin state framework. I mean, that would be my personal view on it. I view the tribes as sovereigns, but they're sovereigns within a sovereign. Now, is that complicated or not? You know, the Navajo tribe people are citizens of New Mexico, Arizona, and Utah. They're citizens of the Navajo Nation, and they're citizens of the United States, and they know that. Actually, they're proud of that. And they're fighting for their rights, as they needed to, and they've been pretty effective. Are they there yet? No. So I don't know what you mean, David, when you say be at the table. They're certainly at the table in the adjudications because they've made their claims. And the adjudications are what is, or the threat of adjudication is what is fueling these settlement discussions that can be approved by Congress.
Yeah, I can address what I was getting at there. I think the tribes should be at the table, and I think a wide variety of interests should be at the table when decisions are made about operating criteria, both long range and the shortage and surplus criteria. I think that tribes should be participating in an overall strategy for complying with the Endangered Species Act. And at this point, the table seats only 7 states. The table is not required by the Colorado River Compact. There is no decision-making forum for the Colorado River. The power is held largely by the Secretary of Interior. The states have rights under the compact, but In the full-blown law of the river, the only right the state has to participate, states have to participate in decision-making is that the governor can be consulted, is to be consulted by the Secretary as the Secretary proposes operating criteria. The custom is to let the states solve the problems, push the states to solve the problems, and then the Secretary wraps his or her arms around the solution.
Just to sort of cut through it all and come to the end of the day, doesn't it appear that in 50 years, the upper basin states are going to be buying consolidated water for California? And for us to be able to continue to drink Colorado River water, that's, I mean, with another 40% of our population, 40% growth in population in the next 50 years, what else can we do?
The upper basin is going to have enough water to continue to grow, even at its present fast pace. It means taking water out of agriculture, it means conservation, and it means planning ahead, knowing what our means are. And our means do not include developing to our full compact apportionment. It probably means some water marketing downstream to give us the capital to finance doing the rest of that solution package.
Thank you very much, Justice Hobbs. David. And thank you all for joining us. And join me one more time in thanking both our speakers and Jan Nystrom and Bob Adler.